Appearing for who?
Appearing for the first and second defendants, my lord.
You are appearing with who?
With Joy Ayara.
Why is Joy Ayara? I have not seen her. I can't. Okay. Yes, this matter is for judgment. The judgment is ready. I noticed that there is no representation for the claimant. The judgment goes like this. It is by the general form of complaint dated 24th day of August 2017 and filed on the same date, the claimant commenced the suit against the defendant, praying for a declaration that the dismissal from service is unconstitutional and void, done without fair hearing. 2, an order directing the defendant to reinstate him back to his work. 3, an order for payment of all entitlements from month of August 2008 at the rate of 22,000 monthly till the date of judgment is delivered. Upon being served with the originating process commencing this suit, the defendant filed a joint statement of defense on the 19th day of December 2017. In proof of his case, the claimant testified as CW1 after identifying his witness statement on oath of 24th day of August 2017. The claimant adopted his witness statement on oath as his evidence in this case. CW1 also tendered documents which were admitted in evidence and marked as Exhibit CWA, CW1B, CW1C, CW1D, and CW1D. One Lieutenant Commander of Govisi, the naval provost officer, testified in proof of the defense of the defendant as DW1. DW1, after identifying his witness statement of oath, adopted same as his evidence of the defense of the defendant in this case. DW1 also tendered 3 documents in evidence which were admitted in evidence and marked as exhibits: DWA, DWB1 to 6, and DWC. The case of the claimant was enlisted into the Nigerian Army as an ordinary seaman, PT of July 2006 with service number 10645. Before his dismissal from service in year 2008, the claimant stated that while on course at Kora in Lagos, upon return from his hometown following the death of his wife, he was detained for 2 months on the ground that he absented himself from. The claimant also stated that on the 4th day of July 2008, after 2 months in detention in custody of the first defendant, without investigation made against him, he was verbally ordered to stop going to work by his immediate commanding officer, an act the claimant claimed was imposed on him contrary to the provisions of the 1999 Constitution of the Federal Republic of Nigeria and the Armed Forces Act. According to the claimant, following verbal order imposed on him to stop coming to work, the claimant kept on writing appeal letters to the defendants through Human Rights Commission and his solicitors. It was until 26th day of May 2017 when he was informed by through his solicitors that the actual nature of the punishment of dismissal earlier imposed on him since the year 2008 was for his absenteeism. That's why the claimant now approached this court to ventilate his grievances. The defendant case is that the claimant was training of PT3 qualifying course at Upper Lagos. When the claimant frequently exhibited lack of interest in the training, in that the claimant was absent on 6 occasions during the training because of the claimant's truancy, he could not graduate with his course mates. The claimant never took any permission, let alone be granted one. The defendant did not maliciously refuse granting claimant permission as no request was made for such. It was stated that the claimant was arraigned before the commanding officer on 6-count charge of absence without leave, wherein the claimant pleaded guilty on all the charges, but was given respite and placed on open arrest in accordance with the service laws, with the hope that he will seize the opportunity to become a better rating. But surprisingly, the claimant further absented himself from his duties on the 24th day of April 2008 and returned on the 25th day of June 2008. The claimant further absented himself from duties on the 24th day of April 2008 and returned on 25th day of June 2008. The claimant further absented himself from duty on 7th occasion for a whooping period of 63 days, and the claimant was marked wrong. Consequently, the claimant was again arraigned before the commanding officer on the 4th of July 2008 on 7-count charge of absence without leave. It was stated that during the trial of the claimant, he pleaded guilty to the 6-count charges, but attempted to defend his long absence on the 7th occasion. Throughout the period the claimant was absent, he made no attempt whatsoever to contact or inform anybody on board NNS Cora about his whereabouts. At the same time, the claimant drew his salaries for the period of absence. At the conclusion of trial for absenteeism, the claimant was found guilty and punishment of dismiss regiment was awarded in accordance with the law. It was stated that the defendant followed due process and claimant was accorded fair hearing. The submissions of the defendant formulated two issues for determinations. They are: one, whether the claimant was dismissed in accordance with the service law and procedure. Two, whether the claimant has proved his case to be entitled to the relief sought. Argument on the issues. Issue one, whether the claimant was dismissed in accordance with the service law and procedure. It is in arguing this issue Mr. Adeba submitted that the claimant was appropriately dismissed from the service of the first defendant. It has been uncontroverted throughout the trial of this suit that the defendants observed the highest standard of military practice, etiquette, and procedure in dismissing the claimant, as the said dismissal was made pursuant to the relevant laws guiding punishment for the offense of absence without leave committed serially by the claimant. According to counsel, there is no doubt that the offense of absence without leave committed by the claimant falls within the category of offenses that may be tried summarily with appropriate punishment meted accordingly. Counsel submitted that the Armed Forces Act provide for 2 channels by which person to whom the act applies can be tried for offenses, for the offenses he has committed. Counsel referred to the provisions of section 59, provisions of section 124, 129, and 59 of the Armed Forces Act. Counsel argued that the import of the sections is that liability of 2 years imprisonment term is when claimant is tried by court-martial. This is not the case here. The claimant was tried summarily. As such, the relevant provision of summary trial in respect of claimant's offenses are applicable, and the circumstances and validity of the claimant's summary conviction lies in the combined reading of section 116131 and section 24(6)(a) of the Armed Forces Act. The provisions of the 2 sections were reproduced by counsel. Counsel further submitted that Counsel also referred to the evidence of DW1 Lieutenant Commander of Boise under cross-examination when he was asked about the nature of the trial in which claimant was dismissed as follows: I am not a member of the court martial. It was summary trial conducted by a commanding officer. It is submitted in furtherance to the powers of the commanding officer stipulated in section 116 above and 1266 delineate the category of officers that may be tried summarily. It is the contention of counsel that the offense of absence without leave provided for under section 59, having been excluded by section 124(6) of the Armed Forces as an offense which may be tried summarily, is appropriately punished under section 116(1)(c). The powers of summary dismissal having been exercised in accordance with the Armed Forces Act in the instant case is indeed valid. Counsel asked the court to so hold, having clearly outlined the statutory validity of the dismissal of the claimant from service. The first defendant contended that the claimant was dismissed without submitted that the claimant cannot contend that his dismissal was without recourse to due process of law. Counsel answered the claimant. Counsel submitted that the claimant's paragraph 5 of his statement of facts clearly admitted his absence without leave and in flagrant disregard for constituted authority. It is also submitted that this piece of evidence, as contained in the claimant's statement of facts, constitute an admission to the effect that he was not given permission to absent himself from work, but on his own volition and contrary to order of his superior officer, he absented himself from duty. It is tried law that an admission or confession is best evidence that every court of law must rely on where it is shown that the admission, confession was voluntary, direct, and unequivocal, as in this case. Counsel relied on several cases that have been reproduced in the body of the judgment, so I will keep reading the cases. According to counsel, the claimant also gave contradictory evidence, which has made him to be a reliable witness. Counsel relied on several cases on this. The cases have been reproduced in the body of the judgment. Counsel commended to the court the Supreme Court case of Bunge versus Governor of Rivers State. In support of this is submission that the claimant gave contradictory testimony. Counsel submitted that it is crystal clear, as opposed to the claims of the claimant, that his dismissal was without due fair hearing and unconstitutional, that the unchallenged, uncontradicted evidence of the defendants placed before this court point to the fact that claimant was accorded hearing, tried, and subsequently dismissed pursuant to the relevant provisions of the Armed Forces Act. Consequently, all that can be said is that the entire claim of the claimant before the court is nothing but abuse of court process. It is submitted that the claimant has failed willfully to establish his dismissal, to establish wrongful dismissal from service, or the first dependent, or that the first dependent violated his right of fair hearing and therefore unconstitutional. Counsel started argument on issue 2 by submitting that the claimant has not proven his case sufficiently against the first and second dependent with material facts to warrant this court to grant the relief being sought by the claimant. It is submitted that a party seeking declaratory must adduce cogent evidence in support. Counsel relied on the case of Alhaji Isiaku Yakubu versus Alhaji Usman Jawola. Counsel also relied on Shitu versus Pashawe and the case of Adesanya versus Aderomu. Throughout the proceedings, the claimant failed to prove that he was wrongfully dismissed from service. of the first defendant or that he was denied fair hearing. The claimant clearly admitted in his complaint that he left work without being authorized to do so. In the circumstances, it is difficult to see how he can claim that his dismissal was wrongful and in breach of the Armed Forces Act. The law is that he who asserts must prove as provided in Section 131 of the Evidence Act and the case of Ebola versus UBA PLC. Furthermore, counsel referred to Sections 133 of the Evidence Act and submitted that in civil cases, burden of proving existence or non-existence of a fact lies on the parties against whom judgment of the court would be given if no evidence were produced from either side, regard being had to any presumption that may arise in the pleading. It is submitted that considering the evidence of the claimant in the light of the requirement of proof stipulated in the Evidence Act, the defendant has failed woefully to discharge, the claimant has failed woefully to discharge the burden of proof placed on him. In support of this, counsel relied on the case of Indul versus Wayo, reported in 2018 LPLR 45151SC. It is also submitted that in the light of the failure of the claimant to prove that his dismissal was null and void or unconstitutional, he cannot therefore be entitled to other relief sought in the complaint, to which he is not entitled to the other reliefs that is reliefs to the complaint. It is submitted that the evidence before this honorable court establishes misconduct of the claimant who absented himself serially from duty without permission to do so. Counsel refers to the claimant oral testimony under cross-examination and affirming his statement of fact already captured above, wherein he admitted the offense of absence from work. According to counsel, all other claims in the instant suit are predicted on the main claim seeking declaration. The failure of the declaration also means failure of all the other claims. Counsel asked the court to dismiss the claimant's action. The submission of the claimant formulated in his final written address formulated a single issue for resolution, to which whether the claimant was given fair hearing when his services the defendant was verbally determined by the commanding officer. In arguing the issue for determination, counsel submitted that it is clear from the pleadings and evidence adduced in this case that the claimant is a soldier, a person subject to Armed Forces Act, Armed Forces Service Law regulation, as well as Constitution of the Federal Republic of Nigeria. The claimant in this case was alleged to have been dismissed from service of the dependents on an allegation being severally absenting himself from duty, an offense contrary to Section 59(1) of the Armed Forces Act. Counsel refers to Section 123 and submitted that the claimant was summarily tried and dismissed from service. It is the case of the defendant that the claimant was summarily tried and dismissed. It is submissions of counsel that, assuming but without considering that he was summarily dismissed, it is the contention of claimant that his case was never investigated and summarily tried by the commanding officer in compliance with the prescribed manner by law, and even given the opportunity to be heard on the allegation for which he was dismissed, an act contrary to the provisions of 1999 Constitution of the Federal Republic of Nigeria and Armed Forces Act. Counsel also referred to Section 117 of the Armed Forces Act, which requires giving an accused opportunity of electing to be tried by court-martial. Counsel submitted that this provision was also not complied with by the defendant. It is argued by counsel that evidence abound that claimant in this case was just detained for 2 months thereafter he was verbally asked to go without any charge in the prescribed manner or any investigation by his commanding officer as required by law, but he was only informed the nature of verbal dismissal action taken against him in 2017 through Exhibit CW1B when he was said to be dismissed. See Counsel also refers to paragraphs 6, 7, 8, and 9 of the claimant's unchallenged on the claimant's evidence on oath as adopted in his witness statement on oath. Counsel also referred to section 36 of the Constitution and submitted that he was not accorded fair hearing. Therefore, his dismissal was null and void. Counsel further argues that where a contract of service is protected by statute, as like in this case, any act not contrary to the statute or terms of employment, and the Constitution render the said act ultra vires and void. For there cannot be unilateral repudiation of contract without compliance with the laws or terms. Counsel relied on the case of Yaba College of Technology in support of this submission. He also relied on Obioha versus Daffy. Counsel also submitted that in this case there is complete breach of fair hearing, as the claimant was not heard or tried before he was dismissed from service. The defendant in their defense appeared to have heavily relied on exhibit DWA and DWB 1 to 6, which are the report of summary trial and monthly punishment returns. This document, it is submitted by counsel for the claimant, cannot avail the defense of compliance with provisions of the requirement and said section 117 and 123 of the Armed Forces Act. Counsel contended that exhibit DWA, being a report on the summary trial, is not and cannot be interpreted to mean the record of summary trial proceeding itself, conducted by the claimant commanding officer. It was signed by OG Obiasi DW1 in this case. Again, it is contended that exhibit DWB 1 to 6, signed by 1JA Ajani, commanding officer, is just the general and monthly punishment return of the first defendant sent and forwarded to the flag officer, and again cannot take place of record of summary trial proceedings of the claimant. According to counsel, there is no evidence available in this case showing that the claimant was in fact a law charge and tried of the alleged offenses of absenteeism contrary to provisions of section 59 of the Armed Forces Act and in accordance with the procedure laid down in the Act and Constitution of the Federal Republic of Nigeria, as he was also never given fair hearing to defend himself of the allegation leveled against him. Counsel relied on the case of Oladele versus Nigerian Army, where he quoted the observation the Nigerian counsel, in concluding his submission, asked the court to grant the relief sought by the claimant and discountenance the submissions of the defendant. Court decision: I have perused the processes filed in this suit, the evidence led by parties, as well as written and oral submissions of counsel for both parties. The defendants, in their final written address, formulated twin issues for determination, while the claimant submitted a sole issue for determination. Having regard to the pleadings and evidence adduced before this court by the parties, I am of the view that a single issue can dispose of this matter, to wit, whether from the facts disclosed by the claimant, he has proved his entitlement to any of the relief being sought from the court. The law is right that a claim is circumscribed by reliefs being sought. The duty of a party claiming, therefore, is to place only such facts and material as are necessary to sustain the reliefs being claimed and adduce evidence to prove same. He may, at the end of the day, obtain all the reliefs claimed or less. He never get more, nor does he obtain reliefs not claimed. A court is therefore bound to grant only reliefs claimed. It cannot grant reliefs not claimed. See the case of Atibi versus Kabel Metal Nigeria Limited, reported in 2008, Nigerian Kilo Report, Fat 1095, page 399. In the case at hand, the claimant is claiming 3 reliefs from his complaint. The first relief is for declaration that the purported dismissal of the claimant is unconstitutional, null and void, and done without fair hearing. The second relief is for an order directing the dependent to reinstate the claimant back to his work. The third relief is for an order for payment of all entitlements. For all entitlements from the month of August 2008 at the rate of 22,000 monthly till judgment is given. It is apparent from the reliefs being sought that the first declaratory relief is the main relief or claim of the claimant, while the remaining two are ancillary, which are dependent on the grant of the main reliefs. There can be no doubt that the fulcrum of the claimant's claim is to contest the validity of the action of the dependent in dismissing the claimant's regiment into the Nigerian Navy. The claimant is by his pleading and evidence stating that the dependent did not follow due process in taking action against him, while the defendant on their part are saying that they followed due process in dealing with the claimant. According to the defendant, the claimant was tried summarily on charges of absenteeism and was found guilty by the commanding officer, and punishment of dismissed regiment was awarded in accordance with the law. In support of this exhibit, DWA and DWB 1 to 6 were tendered. DW 1 to 6 and DWC were tendered and admitted in evidence. For the claimant, he was on course at Kora Apapa, Lagos, when he got emergency call on serious ill health condition of his pregnant wife, consequent upon which he asked for permission to go and attend to her treatment and medication at his hometown in Edo State, but his divisional officer refused to grant him permission. However, due to the nature of the degree of ill health of his pregnant wife, who was profusely bleeding, he had to go to attend to her. While taking his wife to the village, she passed on. The claimant had to arrange to bury his late wife and then come back to his station. Upon returning, the claimant was ordered to be locked up for 2 months, after which, on the first day of July 2008, he was asked to stop coming to work without any specific charge or given opportunity to defend himself of any summary trial. It is right law that where an employee is challenging the validity of his dismissal from service, whether it is from an employment with statutory labor, as in this case, or under the common law, the principles of master and servant, the claimant has a bounden duty not only to plead the facts of the employment and the terms and conditions of service, but must also prove same by cogent, credible, and admissible evidence before a determination of the validity of the dismissal can be considered by the court. Thus, a complaint by an employee that his employment has not been properly determined, he has the onus, first, to place before the court the terms and conditions of employment, and secondly, to prove in what manner the said terms were breached by the employer. It is not in principle for the employer who is a defendant to an action brought by the employee to prove any of these issues. See the case of Francis Kato versus CBN. See also the case of Iwuchukwu versus Wizu. See also the case of Aji versus Chad Basin Authority, and another. The above principle of law, as enunciated in the cases cited, has to be understood that the contract of service is the bedrock upon which an aggrieved employee must found his case. He succeeds or fails upon terms thereof. In the case at hand, since the employment of the claimant is governed by Armed Forces Act, the said act will play a prominent role in determining the claims of the claimant. It is clear from the pleadings of the parties, evidence adduced, and the relevant laws that the dismissal of the claimant from service of the dependent was predicated on the offense of absence without leave under Section 59 of the Armed Forces Act. This is a crime punishable under Armed Forces Act. The claimant has pleaded and gave evidence to the effect that his wife was seriously ill, consequent upon which he asked for permission to go and attend to her medical need, but he was not granted the permission. The claimant went on to state that due to the nature of the sickness, he has to go and attend to her. The claimant further stated that on the way taking her to the village, she passed on. Upon his return to the station, he was detained for 2 months thereafter. On 4th of July, he was asked not to be going to office. For the defendant, the claimant was on a course, but he exhibited lack of interest in the training, and he frequently absented himself from classes that resulted in him not completing the training with his course mates. The claimant was on 4th day of July 2005 arraigned before the commanding officer on 7 counts charges of absence without leave. The claimant admitted guilty on 6 counts, but attempted to defend his long absence on the seventh charge. It was discovered at the trial that the defense of the claimant was nothing but a feeble attempt to cover up the period of absence from duty without leave. Upon verification, the claimant was found guilty and punishment of dismissed regiment was imposed. It is patently clear from the facts of this case, as disclosed above, that the claimant in this case was alleged to have absented himself from work without leave, contrary to Section 59 of the Armed Forces Act. It is to be noted that under the Armed Forces Act, a person subject to the service law, if accused of commission of an offense under the Armed Forces Act, can either be tried by a court martial or charged may be tried summarily by his commanding officer. In the case at hand, the defendants have maintained that the claimant was charged, tried summarily, and found guilty, and punishment of dismissed regiment was awarded or imposed on him. See Section 59. By the combined effect of Section 131, 132, and 133 of the Evidence Act, the burden of proof lies on who assert. Generally, the onus is on the claimant to satisfy the court that he is entitled to the release being sought on the evidence adduced by him, and in doing so must rely on the strength of his case and not on the weakness of the defense. See the case of BP Industry Limited versus Cocoa Industry Limited, 2008, Nigerian Kilolo Report, Part 1105, page 486. See also Pajemerico versus GB Nigeria Limited, reported in 2009, 5 Nigerian Kilolo Report, Part 1135, page 588. In the case at hand, the claimant has onus of proving that the action of the defendant is unconstitutional. From the evidence of the claimant, he has admitted being absent from without leave, but he tried to justify the absence by stating that his pregnant wife was seriously ill and he had to take her home. He had to take care of her medical needs. He further stated that he had to convey her to the village, but on the way she passed on the dependent, which made him to arrange for the burial. The dependent felt this is not enough to exonerate claimant from blame, as they called a feeble excuse. I note that the claimant, apart from ipse dexit, has not tendered any document to buttress the claim of ill health of his wife. There was also nothing to establish that the wife actually died as claimed. In the absence of concrete evidence to support the claim of ill health of the claimant's wife and her death, I quite agree that the claimant has not justified the absence from duty without leave. From the final written address, the counsel for the claimant had referred to Section 123 and 117 of the Armed Forces Act and submitted that these sections were not complied with by the defendant. According to counsel, there was no investigation of the charge against the claimant. It was also submitted that the claimant was not given opportunity of electing to be tried by a court martial before being subjected to any summary trial, if there is any. What counsel had done is to give evidence in the final written address. The law frowns at that, as the law is right that a written address is meant to guide the court on what the position of the parties based on the pleadings and law are. And address of counsel should not be used by counsel to bring new facts and not pleaded. The submissions of counsel on investigation of charges and not giving the claimants opportunity of electing to be tried by court-martials were not pleaded in the circumstances. The counsel is not allowed to give evidence in final written address or bring new facts in his final written address, which is not the appropriate forum to do so. The law is well settled that counsel is not allowed to give evidence in final address. The law is well settled that evidence adduced in respect of facts not pleaded goes to no issue and ought to be disregarded by the court. In this case, the claimant did not plead absence of investigation of charge or absence of giving him opportunity to elect to either be tried by court-martial or by the commanding officer. Court cannot apply facts which are neither pleaded nor proved. See the case of Delco versus Union Bank of Nigeria, PLC, reported in 2004, Nigerian Ukulolo Report, part 862, page 123. See also the case of Emegokwe versus Okadibo, reported in 1973, 4SC, page 113. It must always be remembered that pleading is what circumscribes the extent of the case put forward by the parties. Pleading seeks to sufficiently put the parties on notice about the exact claims so as not to overreach either of the parties. Parties are bound by their pleading. They must not be allowed to go outside the pleading to make a new case before the court as the claimant in this case, as the counsel for the claimant, as counsel for the claimant in this case is seeking to do. The main relief of the claimant is for a declaratory relief, which is discretionary remedy, which is not granted as a matter of course, and that as a matter of course, and the court must because the court must be satisfied before granting it. For a declaration to be granted, the claimant must be able to prove that he has a very strong cogent case, both from the statement of claim and from the evidence he adduces in support thereof. The claimant must satisfy the court that under all the circumstances of the case, he is fully entitled to discretionary relief in his favor. When all facts are taken into cognizance, declaratory reliefs are obtained on the basis of very strong and cogent case contained in the claimant's pleading and evidence laid in support. It is for the claimant to satisfy the court that under all the circumstances of the case, he is fully entitled to discretionary relief he sought or he is seeking from the court. The claimant succeeds on the strength of his case alone and never by virtue of weakness of the defense. See the case of Ebunike versus Mwanke. See also Atra Industry Limited, Nigeria Limited versus MBCI. See also Omishore versus Arebeshola. See also Buhari versus Obasanjo. See also Odulaja versus Haddad Limited. See also Dumes Nigeria Limited versus Nwakoba. See also Bello versus Eoka. See Emenike versus PDP. And Makanjola versus Ajilore. Also Akimbuye versus Babatunde. The law has always been that a claimant has the primary duty to prove his claim based and the evidence act requires and enjoins the claimant as he who asserts to prove his assertion. Even where the defendant has failed to file statement of defense, it is still the duty of the plaintiff, if he is to succeed in his case, to lead satisfactory evidence to warrant the grant of declaration or equitable reliefs in his favor. The claimant in this case, by pleading and evidence before the court, shows that he absented himself as being accused by the defendant, having admitted traveling out of the station without permission. Can the claimant now turn around to claim that due process were followed? Due process was not followed in sanctioning him for his absenteeism? The answer is a capital no. With the admission of the absence without leave or permission, the claimant cannot be said to have proved entitlement to the grant of relief. One, to declare the dismissal of the claimant unconstitutional, null, and void. The admission of absenteeism by the claimant clearly goes to show that the claimant has failed to discharge the burden of proof to entitle him to relief. One, I am not satisfied that the claimant is entitled to declaration being sought. See the case of Bello versus Eweka and Oji Emobom and Titilayo versus Olufo and Omunu versus Agu. I must make it clear that the claimant in this case will not be allowed through the medium of final written address bring new facts which have not been pleaded in the original pleading, and there was no reply filed by the claimant to the defendant's statement of defense. The claimant, by failing to file reply to counter and contradicts the defendant's abatement, has exposed the weakness of the case of the claimant. From the evidence of the claimant under cross-examination, the claimant contradicted his evidence in paragraph 5 of the statement of facts and paragraph 5 of the witness statement on oath, which he adopted as his evidence in proof of his case. The claimant stated under cross-examination thus, I quote, I took permission from my divisional officer. I went to my commanding officer and took permission. No written permission. It was oral. I was not on duty. I was on course. You are not right to say my commanding officer did not give me leave. I was in the, he did not answer me. I was dismissed on 4th of July 2008. The reason of my dismissal is absence from work. It was one time, it was in April, and I returned in May. I took my wife home. I was absent from 24th day of April 2008 and came back on 26th day of May 2008. It was not tried. I was not tried. They collected my shoes. Therefore, the evidence given by the claimant has lost its value as a result of the conflict. This has portrayed the claimant not to be a straightforward person, and his evidence cannot be relied on. He seems to be approbating and reprobating, which is not allowed in law. The claimant has contended the claimant has contended that his divisional officer maliciously refused to grant him permission on one hand, and under cross-examination, he stated that his divisional officer granted him permission orally. The two contradictory evidence cannot coexist. they cannot establish any case. The position of the claimant in stating that he was not tried seems to have glossed over the position of the law regarding summary trial. The law is well settled that cases that summary trial is any proceeding by which a controversy is settled, case disposed of, or trial conducted in a prompt and simple manner without the aid of a jury, without presentiment of indictment, or in other respect out of the regular course of the common law. In procedure, proceedings are said to be summary when they are short and simple in comparison to regular proceedings. This means summary trials are short and fast. Cases tried summarily are disposed of in prompt and simple manner. Summary trial entails immediate action without following the rigmarole in normal legal procedure. In some cases, it is often carried out brevi manu. In summary trials, it is not all evidence relied on by the prosecution that made available to the accused person before trial. See the case of Idigbe versus Federal Republic of Nigeria. See also Alamesia versus Federal Republic of Nigeria. See also Emirates Airline versus Federal Republic of Nigeria. In view of the nature of the trial, of the nature of summary trials, the claimant was not denied fair hearing, as he wanted this court to believe. I so hope. In view of all I have been saying above, the facts are disclosed in the case shows that there was a criminal trial of an offense of absence without leave contrary to Section 59 of the Armed Forces Act. The trial was done summarily. The claimant, who was the accused person, was found guilty, and an award of dismissal of regiment was passed on him as punishment. See Exhibit DWA, DWB 1 to 6, and DWC. The finding of guilt and award of dismissal regiment, being a verdict in criminal trial conducted summarily, cannot be overturned through an action commenced via a general form of claim or complaint, as the claimants want this court to do. If there is a valid process to contest such proceeding, it has to be by way of appeal or use of prerogative briefs. The law is that the procedure for discipline in an employment with statutory labor must be complied with, otherwise the dismissal ensuing thereof will be null and void. See Longe versus First Bank of Nigeria. See also Oloron Toba Oju versus Abdurrahim. See versus Abdurrahim. In the matter of discipline of an employee whose employment has statutory labor, the procedure laid down by such statute must be fully complied with. If not, any decision affecting the right or reputation or tenure of office of that employee will be declared null and void. However, in the case at hand, absence without leave contrary to Section 59 of the Armed Forces Act is a serious criminal offense under the Armed Forces Act that can only be tried in a competent criminal court or a tribunal set up under the law or constitution. This is so because the determination of the guilt or innocence of any person accused of commission of a criminal offense is within the exclusive jurisdiction of a court of law or tribunal constituted in the manner prescribed under the law or constitution. This is the case of military governor of Imo State versus Unwawa. See also Egu versus University of Port Harcourt. In the case at hand, the process leading to dismissal of the regiment of the claimant was not in the exercise of disciplinary proceeding. It was based on criminal proceeding. The dismissal of regiment was an award by the commanding officer of the claimant in the exercise of the power of summary trial conferred on him by the Armed Forces Act. From my finding after appraisal of the pleadings and the evidence adduced by the parties, I came to the irresistible conclusion that the claimant in this suit has not convinced the court of his entitlement to grant of declaration being sought due to lack of concrete, cogent, and compelling evidence that will enable the court to grant a declaration as being sought. The remaining two reliefs are ancillary, dependent on the grant of the main relief one, that is declaration. The declaration having failed, the ancillary reliefs must also fail, and all are hereby dismissed. In the circumstances of the case of the claimant is hereby dismissed for lack of proof. I make no order as to cause. Judgment is entered accordingly.
As the court pleases.
Yes.
We're very grateful, my lord.
You are welcome. Any other matter? Thank you, Council, for your presence. We have come to the end of the virtual sitting. The administrator, you can end the sitting. Thank you.
Thank you very much, my lord.